Good afternoon, ladies and gentlemen. Today we will discuss very fundamental principles in labor law and jurisprudence. And this is about the very basic rules on employer-employee relationship, and also the status of employment of whether an employee is regular, casual, project, fixed term, seasonal, especially in the light of the discussions in the hearing in Congress today about employees of ABS-CBN and other networks, whether they are independent contractors or they are employees because of the element of control. And also, we will go to job contracting and labor-only contracting. So, brace yourselves for a very animated discussions on these fundamental issues. Our topic is very important because many topics on wages and salaries, benefits, unions, collective bargaining, and termination of employment would depend on whether or not really there was employer-employee relationship. So one of the questions that we will answer tonight is, can there be a labor dispute when there is no employer-employee relationship? We will now start on the issue of employer-employee relationship. You have heard this, and you can have a mnemonic device, something to remind you, which is it's CCT or Hikokoti, hiring, compensation, controlling, and terminating. So when there is an issue of employer-employee relationship, you should ask the question, did you hire this person? Who paid his wage or salary? Do you control his behavior? In other words, if he commits a mistake, are you subjecting him to memorandum to explain? Are you subjecting him to employee discipline? And the best evidence that a person is your employee is when you issue a notice of termination. Because you cannot terminate a person who is not your employee. Parang sabi ni Saya pa, dili nimo mahimong buwagan kung dili mo uyab. So kinahanglan nga doon naging may relasyon. So by terminating a person or the employment of a person, you are admitting employer-employee relationship. Kaya moingon man ang empleyado nga gi-isyuhan nimo og memo of termination, kung dili naging tayo, kung hindi naging tayo, bakit mo ako hiniwalayan? No? That is very simple. So you cannot terminate the employment of a person if there was no employment at all. So you have to remember that. You have to remember this hikokote, dismissal or termination. Hikokodi, hiring, compensation, control, and dismissal. Pero in my case, in my teaching in Manila, in UE, in UST, in San Sebastian, in San Beda, Alabang, I use only the 3C. 3C means contract, is the act of hiring. Compensation is the act of compensating. Control is divided into two, discipline and dismissal. The contract is the meeting of the minds between the putative employer and the putative employee. Yung I do that you may give, I give that you may do. So I give you your salary so that you do your work. I do that you may give. I perform the task so that you pay me my compensation. And the most important element is control, because a person may be working for you, but he is not your employee. He can be your agent. What is the difference between an agent and an employee? When I give you my ring and ask you to sell my diamond ring, then I tell you, you can sell it anytime, anywhere, but next Monday, you come back. If the ring is sold, you give me the amount of 100,000 pesos. If you sold it 120,000, the 20,000 is your commission. But you either return the ring unsold, or you give me 100,000 pesos this coming Monday. That contract is not employer-employer relation. That is agency. Because I'm interested only on the result. I do not monitor you as to what is the time for selling, where you sell, the manner of selling. I don't care, as long as you give me the result. That is the contract of agency, not employer-employee relationship, because of the absence of control. No? You do not become an employee. Just like when you are selling online Lazada products or whatever products, you are selling insurance policy, you are selling beauty products, you are not employees of the owner. You are only an agent. And so you cannot demand the terms and conditions of employment as provided in Book 3 of the Labor Code. Is that clear with you? No? That should be very clear. In other words, you cannot go to the NLRC and file a case of illegal dismissal if I stop giving you products because I am not happy with the way you sell my products. You are delayed always in remitting the sales, and there are many complaints from the customer. So I decide to stop the agency relationship. Now, since you have finished taking up the books in Civil Code, Book 1, the family relations, Book 2, the property ownership and its modification, Book 3 is the modes of acquiring ownership including wills and succession, Book 4 is obligation and contracts, and the special contracts in Book 5. But there are really only Book 4 books. So since you are done with that, you know what is agency. You know what is the contract of partnership. Partnership is when two or more persons agree to contribute money, property, or industry with the intention of dividing the profits between or among themselves. There is no employer-employee relationship between partners. There is no control. So you have to distinguish employer-employee relationship with agency and with partnership. So if there is no employer-employee relationship, there is no basis to demand for salary. There is no basis to join a union for collective bargaining. You can join a union for mutual aid and protection but not for collective bargaining, because there is no relationship at all. So if there is no relationship, the labor code as a general rule will not apply. But I will show you later on that there can be a labor dispute even if there is no employer-employee relationship. So you cannot discipline a person who is not your employee. Parang anak ng kapitbahay mo, ng anak sa imong silingan, as inyong bahay, tapos nagkasala, dili na nimo mahimong bunalan, kay dili man na nimo imong anak. You have to tell the parents. You have no parental authority over the child. So in the same case that you do not have an authority over a person who is your agent, you can only terminate the agency or exercise other options, but not discipline, because discipline presupposes employer-employee relationship. So all this, employees have rights to wages and benefits, and employees have the duty to obey their employer. Once you accept a job or an employment, it is an implied stipulation, it is part of the prestation that you have to follow the policy. Di mo pwedeng sabihin, sir, narabaho ko, aman may magsabot na iya kong disiplinahon. It is implied. Kung mudawat ka sa imong sweldo, mudawat ka sa imong trabaho, apil na mudawat ka sa pagdisiplina sa imong amo. Kariyar magminyo, yung nagminyo may, may labot na magdulog may. That is part of the package deal, no? So, not everything can be stated in the contract. There are stipulations that are generally accepted, that it is universally accepted as part and parcel of the agreement. Employees can be disciplined, the labor code would apply, and they are entitled to statutory benefits. Now, in the case of Jack Valencia versus Classic Vinyl, the Supreme Court said that the question of employer-employee relationship is a question of fact. In other words, when you hear the phrase question of fact, that means there must be evidence. Whether the evidence is testimonial evidence or documentary evidence, as long as there is evidence. Now, you know what is the meaning of evidence. Well, in labor law, we do not need proof beyond reasonable doubt. So, do not ever think in your mind that you cannot prove employer-employee relationship if there is no written contract. Because there are many people who are hired without a written contract, and yet, in the eyes of the law, they are employees. No, because a written document is not a necessary element. It's not necessary to have a written document. The mere meeting of the minds, I do that you may give, I give that you may do, it consummates the agreement. That's why there is such thing as constructive hiring. Kung may narinig kayong constructive dismissal na alam ninyo, you should also be familiar with the concept of constructive hiring. Because when you have a factory, for instance, ikaw, Mr. Carrion, you have a factory, and one day, a lady by the name of Miss Badwell comes into your factory, and without being recruited, without being formally hired, he just started working. And you, the owner, you are aware of that, and you did not stop her. And she continued to render work, and during the paydays, he is now demanding salary. And you said, why are you demanding salary when I did not hire you? Well, you allowed me to work, and you benefit out my labor. There is a constructive hiring. Kumbaga sa mag-boyfriend, yun ang tinatawag na MU. Na doon ay mga babae o mga lalaki nga dili na sila mag-ulitaw-hanay, pero nagkita, nag-eyeball, naghawakay sa kamay, tapos nagpunta sa motel, nabuntis, o niya, nanay anak, niya, mangutana ka, niya, tayo na bang dalawa? Anong tayong dalawa? Action speaks louder than words. That is employer-employer relationship need not be documented because it is already consummated. Huwag mong sabihin na hindi tayo related, na tayo ay nagkaanak na. Or huwag mong sabihin na hindi mo ako empleyado after na napakinabangan mo ang aking trabaho. Ganon. Yan ang constructive hiring. Later on, punta tayo sa constructive dismissal, doon naman siya gitawag og constructive resignation. Katong naitabo ni Presidente Era, na nasa Mibiya siya sa Malacanang. And at that time, si Gloria Macapagal Arroyo, who was the Vice President, was taking her off of office. How can you take oath to an office that is not vacant? You cannot fill up a position that is not vacant. So, the Supreme Court was forced to declare that there was already a constructive resignation because nung nagsalita sa Iraq na ako, dili ko gusto nga doon ay madugo na pangyayari, hindi ako gusto kaya aalis ako sa Malacanang. That was understood as abandoning his position, and that was the rationale why the Supreme Court upheld the validity of the assumption to office of President GMA. So remember, tonight you learned that there is constructive hiring, there is constructive resignation, and there is constructive dismissal. Okay, so the burden of proof rests upon the party who asserts. So, if you are a person and you claim to be my employee, at least you show something, ID or a part of the payroll or whatever, just a letter, for instance, addressed to the bank. Bearer is my driver, he's our employee, please entrust the money to him. That can be an evidence of employer-employee relationship. No? Even if you are not in the payroll. No? To be in the payroll is not an element that proof that you are not an employee of the company. So, absence of employer-employer relationship. It was found that not one of the following elements were present in the case of Charlie Hiao versus BCC Product Sales. This means that Charlie was a salesman, an independent salesman. When you are an independent salesman, as I have said earlier, you are selling beauty products or you are selling some insurance policy or Lazada products. You do not become an employee of the owners of the product because of the absence of control. No? So this is repeated and repeated in many cases. What is the legal implications of absence of control? The answer to that is the implications of absence of control by the company on the manner, take note ha, manner, means, or methods, tatlong N. Manner, means, or methods by which the employee renders work. If there is no control by the putative employer, then you can conclude that there is no employer-employee relationship. Now, this is a very good bar question. Can there be a labor dispute if there is no employer-employee relationship between the worker and the employee? Well, most of you will answer no. There can be no labor dispute because you always think that employer-employee relationship is a necessary element to a labor dispute. But if you go to Article 219 on the definition of labor dispute or industrial dispute, the second article of Book 5 of the Labor Code, there are definitions. And one of the definitions there is the definition of industrial dispute. And it's very clear there that there can be a labor dispute even if the parties do not stand in the proximate relations of employer and employee. Now, I remember very vividly this case of San Miguel Union, PTJWO versus Judge Jesus Bersamera, because I was a lawyer of San Miguel and my boss was the former Justice of the Court of Appeals, Justice Francis Hardilesa. Justice Francis Hardilesa was the Chief Legal Counsel of San Miguel. I was the Deputy Chief of Legal Counsel in charge of labor litigation. And it happened that there was a strike in Magnolia. Magnolia ice cream used to be owned by San Miguel before it was sold to Nestle. So Magnolia was our branch. In fact, I recruited a Cebuana, who is my distant relative from Alcantara and Ronda, who used to be an arbiter, Attorney Alhambra Alpafara, to be the counsel of this Magnolia. But I was in the head office. I was in charge of all the labor disputes of San Miguel. So there was a strike in Magnolia involving employees of the agency, not employees of Magnolia, agency, because, you know, in San Miguel, the employees are entitled to a lot of leaves, vacation leave, sick leave, emergency leave, study leave. So every day there's somebody or many people are on leave. So the company got people from the agency to replace those who are on leave. And there are people who have been there for 20 years, for 15 years, and they just, every day they are just waiting to be called because they are going to replace those who are on leave. So these people join the union of the rank and file, the regular rank and file, which is affiliated with PTGWO, Philippine Trade and General Workers Organization, which is aligned with TUCP and ALO, so they are or aligned. And these workers who are supposed to be contractuals stage a strike. And so the question that was posed to us is this: where are we going to go for relief? To the Department of Labor or to the court? Well, my position is to the Department of Labor because this is about a labor dispute. But my boss, who is a bar top-notcher and a very brilliant student from UP, ako UB ako siya UP. So, siya may masunod. Ingon siya nga, kung maadto ta sa Doli, impliedly admitting tag employer-employer relationship with these people who are not our employees, they are employees of the agency. So, nakarating yan, nag-issue si Judge Bersamira ng injunction telling the strikers to cease and desist, to stop striking because they are not employees. And then the union went to the Supreme Court. Justice Amuerfina Melencio Herrera, writing for the court, said that there can be a labor dispute even if the disputants, even if the parties to the dispute do not stand as in approximate relationship of employer-employee. Assuming that there is no employer-employee relationship, but what is being fought for, the issue under contention, are terms and conditions of employment, because the strikers, then that is a labor dispute. And so, Judge Bersamera had no jurisdiction. And so the injunction was nullified. And my position as a UB graduate was vindicated by the Supreme Court. But anyway, it is a very important case, and you should remember this. If I were the bar examiner, I will ask this question: can there be a labor dispute even if the parties do not have employer-employer relationship? On the other hand, in this case of Indophil versus Adviento, written by Justice Peralta, who is now the Chief Justice, who is, by the way, my neighbor here in BF Homes, Parañaque. The question is, even if you are an employee, if you file a case of culpa aquiliana or torts and damages, kasi ito si Engineer Adviento, pinailan niya ng kaso yung employer niya dahil nagkasakit siya, which made him permanently and totally disabled because of the obnoxious chemicals which inflicted heavy damage on his health. And this case was filed before the Regional Trial Court of Bulacan. And the management said that you cannot do that because you are an employee, you are filing a labor case. But the Supreme Court said, no, this is not a labor dispute. This is a civil dispute. And he is asking for damages arising from culpa aquiliana. Torts and damages ang sinabi dito. This is a very rare case. So, because of employer-employer relationship, many things can happen and many questions can be raised and many issues can be resolved and decided by the Supreme Court. Suffice it to say that we always adhere to the four-way test. So the question now is, are drivers on boundaries considered employees of the taxi operator? Okay? In 1977, when you were not yet born, I was already a labor arbiter at the age of 26 or 27. I was appointed by the President at a very young age, because at that time, to be a labor arbiter, you do not need some years of experience in labor relations as long as you are a lawyer. So I was appointed, first batch na appointee ako, and I was assigned here in Cebu. And then the question is that these drivers of taxi drivers, ang abogado, taga-UBSAD, no? Si Attorney Alan Necesario, namatay na yung taon, no? Batanon pa kayo. Bright tong bataan. Unya, siya may abogado sa mga driver. Unya, ang abogado rin sa pikas, mga taxi, taga-UB sad. Unya, ang arbiter taga-UB man. Niya akong giingon, mo inhibit ko ani nga pareho man tatagayubit tanan. O, ningon siya, ay lang inhibit sir, kay pareho ratang Bisayan yan, fair tatanan, butang yun as minutes, nga di ko mo inhibit. So, ang question karon, are drivers on boundary considered? Kasi, kining mga driver, for the first time, nang hingi ng tinatawag na 13-month pay. You know, bagong-bago pa ang 13-month pay, no? 1977. Remember that the Presidential Decree 851 granting 13-month pay to the Filipino workers was promulgated by the President. It was not a Republic Act, it was a Presidential Decree promulgated by virtue of the authority vested on him as the Commander-in-Chief of the Armed Forces of the Philippines pursuant to Proclamation 1081, whereby the President governed the nation, abolished the legislative body, and he was the only one who could legislate. So bago lang yun, 1 year lang. Tapos ang question ng mga driver, kami, empleyado mami sa mga operator, mangayo po may 13-month pay. Kunya niingon man ang mga operator, dili mo mga empleyado, kamo mga partner kamo. So ang relationship is partner, not employment. Bakit partner? Kasi you are the industrial partner, kaming mga operator ang capitalist partner, because we agree to contribute our money, your industry, and we divide the proceeds. No? Are you listening to me? Okay. So, ngayon, kung ikaw ang arbiter, how do you decide? Ako ning cross-examine ni mga driver. I put them in the witness stand. I was a very young arbiter at the age of 27. And I asked them the following question. Were you hired by the taxi operator? In other words, you applied to become a driver and you were accepted. There was a meeting of the minds whereby you promised to do and they will promise to give. Yes, sir. So, pumasok na yung ebidensya ng selection or engagement. Pangalawa, how were you paid your compensation? Boundary, sir. Certain amount is given to me beyond. If the boundary is 800 pesos a day, any amount beyond that is our compensation. Okay. Now, this is the most crucial question. If you commit a mistake or you are accused of reckless imprudence and you cause damage to the taxi unit, were you subjected to employee discipline? Were you asked or ordered to explain? Yes, sir. Can you show some exhibit or document whereby you were disciplined by the operator? Yes, sir. I have a copy of the memorandum. I have a copy of my explanation. And here is the decision of the company, which I mark as exhibit by the labor arbiter for purposes of deciding this case. So, ladies and gentlemen, the conclusion is inevitable that there is control. And there is control, that is the best indicator of employer-employee relationship. No? So, the conclusion is that the taxi drivers are employees of the operators. They are not agents. And so they should be paid 13-month pay. Ang problema, how do you compute 13-month pay when the daily income is not regular? Well, that is a matter for computation. But on the legal issue of employer-employer relationship, it is settled that they are employees. So if they are employees, they are entitled to all the rights and the benefits So, control is very important because in the absence of control, there is no employer-employee relationship. Okay, so this case of deliverer of bills and mails. Merong isang tao, si Rinaldo Heraldo, na sugo-sugoon sa isang kumpanya para maghatod og suwat, mag-deliver aning mga packages, and then yung pag-deliver niya hindi daily, on a need basis. Ang question, just because you are not reporting daily means that you are not an employee, as long as there are 4 elements. The 4 elements of hiring, compensating, controlling, and terminating or dismissing. Even if there is less than the regular number of working days. When an employee is repeatedly or hired for so long, ito importante ito, si Justice Leonen ang ponente dito, 2018, yung trabahante sa isang poultry farm na nag-alaga ng mga manok for so long a time, pagkatapos ang depensa ng employer ay hindi naman yan regular employee, kundi casual lang, casual forever. So, sabi ng Supreme Court, the length of engagement is an indicator that his job is usually necessary or desirable to the usual business or trade of the employer. Therefore, he is regular employee. So, kung hindi naging kayo, hindi kayo pwedeng maghiwalay. So, without employer-employee relationship, there can be no illegal dismissal. So, paano mo ako pailan ng illegal dismissal? Hindi naman kita empleyado. So, as a necessary condition precedent to a case of illegal dismissal, there must be employer-employee relationship. Because without employer-employee relationship, there is no cause of action. Rolando de la Roca versus Eduardo Dabuyan. Kasi ito, nangyari nito, yung may-ari ng building, halimbawa, may-ari ng building si Attorney Wagas, tapos si Mr. Bordalba, merong opisina dyan sa second floor. Tapos may empleyado siya na si Iris, si Chris empleyado niya. Tapos nung pinailan ng kaso ni Chris, akala niya si Bordalba at saka si Wagas iisa lang. So sinama niya yung kaso niya, pinailan si Atty. Wagas na wala may labot si Atty. Wagas sa kaso. Ang employer si Mr. Bordalba man. So madali lang lusutan. Bakit? Bakit mo ako isama sa employer sa kaso mo illegal dismissal na may-ari lang naman ako ng building? I'm not your employer. Your employer is the one occupying one of the floors of my building. Di ba? So kung wala tayong relationship, wala tayong cause of action. Like this Nestle case. Ang Nestle kasi ang may-ari ng mga produkto. Tapos ito si Bene Puedan ay empleyado ng distributor ng Nestle products. So, kung si Bene Puedan is not paid his salary, hindi niya dapat isali ang Nestle sa pag-file ng case because Nestle is just the owner of the product. For instance, Nestle is the owner of the product and Mr. Carrion is the product distributor. So, Mr. Carrion purchased the products from Nestle and he hired Bene Puedan as his employee. So if Bene Puedan has a complaint against Mr. Carion, Nestle should be out because Nestle is just a seller of the product. He is not a principal employer in a contract of labor only contracting. There is no privity of contract between Bene Puedan and Nestle. Kita mo, that is very important. Ito, illegal dismissal ito, pero we will reserve this for when we go to book 3. Now, we will go to very basic terms. When you talk of regular, or casual, or seasonal, you're talking about the position, not the person. So, ladies and gentlemen, when you say, regular ka na ba? Mali na tanong yan eh. It's a wrong question. Dapat ang tanong mo is, permanent ka na ba? Ang tanong mo is your position regular? Then you, the incumbent, are you permanent? Kasi pareho sa balitaktakan sa ABS-CBN, yung bang cameraman is a regular position? If the cameraman or yung production assistant is a regular position, the incumbent may be probationary, temporary, or permanent, or fixed term when we go to the tenure. So, you have to clear this in your mind na when you talk of regular, casual, seasonal, or project, you refer to the position, you do not refer to the person. And when you talk of status, whether permanent, temporary, or probationary, you talk about the incumbent who is occupying the position. So it's possible that a regular position is occupied by a temporary employee. For instance, nabuntis yung employee, nabuntis, babae, nabuntis. So we have to find a temporary substitute. The substitute is occupying a regular position kasi yung position ng secretary is regular. Pero siya ay temporary lang. In fact, ang tenure niya definite because once the regular secretary reports back to work, his or her tenure will stop. So you have to make it clear that the position is different from status and status is different from tenure. So position is the name of the job, like HR manager, engineering supervisor, machine operator, or lineman. That is the position. Now the question, is this position necessary or desirable to the business of the employer? If the answer is yes, this is a regular position. Even if the incumbent occupant is not permanent yet because he is probationary, or he is temporary because he is just a substitute. No? And then the status is the official standing of the incumbent. You are temporary o IC ka lang, or you are probationary waiting to become permanent. So, pag ikaw probationary ka, huwag mong sabihin naging regular ka na ba? No. Dapat sabihin mo naging permanent ka na ba? Probationary ka, naging permanent ka. Pero yung position ay regular. Oh. Naku, ang daming hindi marunong sa ganong very basic. I know, kayo, hindi lang nyo aminin sa akin, na kukonfuse din kayo eh. Kasi ang professor ninyo, hindi masyadong pinaliwanag yan. Sino yung professor na 20 years experience sa San Miguel 12 years, Pepsi-Cola 5 years, Petron 3 years. Ako, HR ko. Alam ko yung trabaho na yan. 25 years sa gobyerno, 20 years sa private sector, at hindi basta-basta mga kumpanya. Kaya nga pinapaliwanag ko sa mga estudyante ko yan dahil ang ibang mga professor, basta na lang, diretso na lang sila, parang inasyong na lang nila na makaintindi na kayo, bahala kayo sa buhay nyo. Pero ako, kung sabihin niyo spoon feeding itong ginawa natin, karamihan ng mga estudyante natin, mga working student, kailangan walang panahon magbasa. Kung spoon feeding man yan, kahit sabihin mo pang mouth-to-mouth resuscitation, gagawin ko para lang maging abogado kayo. Ganyan ang pagmalasakit ko sa inyo. Tapos hindi pa mumuatin. Katarungan, unyang mo-release ng bar, ano ako kupasa? Pamuntaan na alay yung kagalingon nyo. No? Because ito yung bisa mag-ampo ba mo kada adlaw magluhod-luhod mo, di mo magtuon, di mo kapasa, kay lihok tao, kay tabangan di ka. Pero di mo mahimo nga i-delegate mo sa Ginoo ang pagtuon, ikaw gid mo tuon. No? Kay mauning bar, way dato, way pobre, dagang anak congressman, bagsak sa bar. Way dato, way pobre, babae, lalaki, bisag bayot, basta magtuon, kapasar gyud. No? Okay. Ito, dito regular employment na tayo. The law, Article 295, says that unemployment shall be deemed to be regular. Remember, the employment ang regular, hindi ang employee. Yan ang tandaan nyo. Pag sinabing unemployment shall be deemed regular, hindi yung tao ang regular, kundi yung posisyon, ang employment, where the employee has been engaged to perform, which are usually necessary or desirable. Kadaghanan na ni tanan jud ma-regular kay ug di ka necessary, desirable na bitaw ko'y amigo, duha ka box secretary. Ang usa necessary, ang usa desirable. Di pareho sila regular. Pero ang word na desirable has nothing to do with beauty. It is in relation to the business or trade of the employer. So, there is a phrase that is modified. Desirable modifies the phrase in the usual business or trade of the employer. Okay? Now, there is another kind of regular employee, the second kind of regular. Even if your job is not necessary or desirable, if you rendered at least 1 year of service, whether that service is continuous or broken, you shall be considered regular insofar as that activity is concerned. O, tingnan mo dalawang klaseng regular. May regular because it is necessary or desirable yung job. Or kahit hindi necessary, pero you last for at least 1 year. Oh, of course, pag wala na yung activity, pwede ka na rin tanggalin kasi wala na yung activity na yan. But insofar as the activity is concerned, you are regular. This is considered as limited regular. Regular in a limited sense. Regular position with a limited tenure. Because it is coterminous to the presence or the presence of a certain activity. So kung i-hire kayo ni Attorney Wagas na technical assistant sa bar review ni Attorney Jimenez, yan napatagal na more than na 1 year na, as long as that activity exists, you are regular insofar as that activity is concerned. Yan, yung mga empleyado ng BPO industry. Itong kaso ni Socorro Inting versus Inod Data. There is an opportunity to distinguish what is regular and what is project. Kasi ang mga BPO, may kanya-kanya silang kliyente. Assign ka sa isang kliyente sa Europe, yung isa sa Amerika. Pag naputol na yung kliyente na yan, hindi na nag-renew, putol na rin yung serbisyo mo. But if you have been transferred from one project to another, and you attain tenure, in the eyes of the law, what started as a project employment has ripened into a regular employment with permanent status. So, carpenter and maintenance workers of UST, alam nyo, kahit sa UB, meron niyang mga mag-repair ng mga lingkuranan, mga aparador, mga gamit sa opisina ni Atty. Waga, ni Dean, hasta ng office ng presidente. Kanang mga carpenter sa UB, dugay naman na sila diya. Pareho lang po sa UST. Kaya sa UST, abot na nag-30 katuig, 20 katuig, unya ilang ingon nga casual naman na, sir, dili man na regular. Pero everyday, can you imagine, sa laki ng UST, sa pinakamalaking campus, kaya ang bar examination doon ni-hold sa UST, kasi buong block yan, kanang gitawag og Espanya, anto dito sa likod. Pag ikot niya, eskwelahan pa kuna ni Rizal, panahon pa ni Jose Rizal, panahon pa ni Manuel Quezon, si Don Sergio Osmeña Sr., diha ko na maabogado, si Diosdado Macapagal, diha maabogado sa UST. Yan kani mga carpenter, nangulipas ang management nga, they are not regular employees. Ang sabi ng Supreme Court, si Justice Estela Perlas Bernabe, the senior associate justice next to the Supreme Court, now nagsabi na the carpenters of UST, electricians, they are all regular employees. So the management administration of UST is ordered to reinstate them and to pay them back wages with interest. So, the exception of regular employee is what you call fixed term and seasonal. So, seasonal and fixed term is considered as exception to regular. For instance, fixed. When you are a dean, Dean Wagas, you are appointed as associate dean by the Board of Trustees for a period of 3 years. After 3 years, we will evaluate whether to renew your appointment. Suppose hindi ma-renew, si Dean Wagas will now be reverted as faculty member. Of course, that will mean a reduction in pay. But is that an illegal dismissal? No. There is a case entitled Lasaret of Santiago Isabela versus NLRC. A faculty member in the College of the Business Administration was promoted as dean with a limited tenure of 2 years. After 2 years, the Board of Trustees evaluated the performance and they found that she is a good faculty but not a good leader. She could not motivate the faculty, she could not cause obedience to the school regulations. She is a failure. And so, she was not dismissed. She was only reverted to her position as faculty member. She filed a case alleging that this was a constructive dismissal because it was a demotion. But the Supreme Court said that you know very well that your appointment was fixed. There was a fixed term. So you have to honor that because you are you are an educated person. You are not like a construction worker who is compelled to sign a document without understanding the contents thereof. That's why the wording of the law is any written agreement to the contrary notwithstanding, and regardless of the oral agreements between the parties, when a person is made to perform an activity that is usually necessary or desirable, yan ang sinasabi. Kasi hindi niya naintindihan. So any written agreement in the eyes of the law, he is regular. Pero dito, din kay. Hindi ka pwedeng sabihin na niloloko ka na administration. So, specific project or fixed term employment is not prohibited by law. Do you know the leading case of Brent International School versus Ronaldo Zamora, which was decided by Justice, the Dean of the former Dean of UST, who became Chief Justice. He was the ponente in the case of Brent versus Zamora. And this case started in 1973 before the Labor Code. A certain person by the name of Norman Allegri was hired by Brent International School, a famous and very expensive international school. This is run by Protestants, and this is where the children of Senator Pacquiao are studying. And that is the reason why Senator Pacquiao became a born again, because of this Brent International School. But that is just a side story. Norman Allegri was hired as education director for a period of 5 years. 5 years period. So that was 1973. There was no labor code. That agreement was valid under the civil code because the stipulations are not contrary to law, public policy, moral, or whatever. So it was recognized as valid. Now, after 1 year, the labor code was promulgated, and in the labor code there is a provision that any written agreement to the contrary notwithstanding, and regardless of the oral agreements of the parties, when a person is made to perform an activity that is necessary or desirable, that person shall be deemed to be occupying a regular position. Well, so after 5 years, Mr. Allegri was informed that his contract would not be renewed, and that therefore this person filed a case, and the case is illegal dismissal. At that time, labor arbiter was appealed to the NLRC. From NLRC, appealed to the office of the Secretary Blas Ople. The decision of the arbiter and the NLRC and Blas Ople, and was affirmed by Ronaldo Zamora, who was the executive secretary of President Ferdinand Marcos in 1977, affirmed the decision. What was the decision? That Norman Allegri was already regular, that Brent could not terminate his services. Now, this case was affirmed, was appealed to the Supreme Court. And Chief Justice Andres Narbasa, that is the name, Andres Narbasa, he was the one who penned the decision before he became Chief Justice. And he said, and he reversed the decision of Ronaldo Zamora, Blas Ople, NLRC, and the labor arbiter, and said that it is not the intention of the court to anathematize or to prohibit employment with specific periods. The parties are free to stipulate on the period, and the stipulation is not null and void because there was no moral ascendancy, there was no deceit, there was no misrepresentation. It was a valid agreement prior to the labor code, and Norban Aligre was bound by the terms and conditions of that employment contract. So, ladies and gentlemen, you have to remember that when the status of employment should be determined based on the provision of law and also the facts of the case. That's why I told you last meeting that in every answer that you will give in the bar, you always use the labor code. You always cite according to Article 295 of the Labor Code, or if you do not remember the number, according to Book 6 of the Labor Code, when a person is made to perform, yan, i-cite mo yan. Because that is the basis of your answer. If you answer a question in the bar without any citation of law, you are only expressing your opinion, and the Supreme Court is not interested in your opinion. Okay? So, we have decisions. In the case of Philips Semiconductor versus Padre Gila, Article 280, which is now 295, was cited, and the language of the law it says manifest the intent to protect the tenurial interest of the worker. So this is the spirit of the law. When you say any written agreement to the contrary notwithstanding, that provision is really for the protection of the lowly employee who is subject to the domination and control of the employer. Pag nag-apply ka ng trabaho, pagkatapos ikaw manggagawa ka na wala ka namang pinag-aralan, tapos pinapirma ka ng contract mo, reklamo pa ka, magay ka kasabot sa imong gipirmahan. So pirma lang ka kay gusto magtrabaho, pero later on, you are not under estoppel. You can, if you find a lawyer who will fight for you, you can raise that as an issue. And the company will not say, you signed this contract, you are bound by this contract. But any written agreement to the contrary notwithstanding, and regardless of the oral agreements of the party, it is the nature of the job in relation to the law that will be the determining factor. It is not the agreement. It is not the written contract that will prevail. It is the reality as tested in the eyes of the law. Tama? What determines whether a certain employment is regular? Employment, not a person, is not the will or the word of the employer to which the disparate worker open accedes. So, bisag unsa pa ibutang nimo sa papel nga gipirmahan sa empleyado, ganang gibutang niya sa papel is nothing. Any written agreement to the contrary notwithstanding is nothing. It is, what is the job? Is that job necessary to the business of the employer? That is what will govern, not what is stated in the contract. Especially, it is contract of adhesion. The only participation of the employee is to affix his signature. Now, yung manner of paying his salary, dili man na mo empleyado kay pakyaw raman na siya. Ang pakyaw is just the manner of paying his salary. Boundary raman na siya, sir, dili man na empleyado. Kanang masulti anawa mag-eskwela sa UB, mga bugo na. Mga bugo. Ngano? Ang manner of paying is not indicative of absence of employer-employee relationship. Sigari, gawa na mag-eskwela sa Gulyas Law School. Kaya nag-eskwela pa na sa Gulyas Law School, may na, any written agreement to the contrary, and regardless of the way he is paid his salary, it's still a salary. Bisag may yung kampakyaw, that is just also a salary. Nga dili, gibase sa oras ang imong sweldo, kundi sa imong output. Isipin lang ninyo ha, may provision sa Book 3 sa Labor Code. Kanang mga waitress, kanang mga babae nga gitable, nga nagtrabaho sa mga bar, they are considered employees of the bar. Basahin ninyo. Pangitaan niyo ang provision. Bisang inyo pa nang i-table o niya, mubayad mo dito sa cashier o niya, i-take home ninyo ng babae. In the eyes of the law, they are employees of the bar. So they can form a union. They can also demand for 13-month pay. Because when there is employer-employee relationship, everything else will follow. It is the nature, according to this case, it is the nature of the activities. No? Considering the circumstances, including the length of time, that will determine. If you cannot prove project or contractual basis and you have the burden of proof if you are the employer, then the presumption is he is regular. So he who alleges that he is not regular will bear the burden of proof. No? Very, very important ito eh. Yung mga membro ng work pool ng, huwag niyong sabihin na construction company tayo, puro project ang empleyado. Not all the employees of a construction company is considered project. There are members of the work pool that will be taken from one project to another, whether there is a disruption or an interruption of the tenure, it's the same. They are regular employees. In the case of DM Consonhe versus Estelito Hamin, that principle has been enunciated again. Estelito Hamin was a carpenter. He was working for more than 40 years. 40 years. He was sent to Brunei twice because the palace of the Sultan of Brunei, Sultan Bulkiah, was constructed by DM Consonhe with a gold dome. Yan, one of the most expensive palaces in a small country like Brunei. Sinong gumawa ng palasyo nila? Ang construction company, DM Consonhe. Ang pinadala doon si Estelito Hamin. 2 beses pinadala. Tapos nung nag-retire na si Estelito Hamin, sinabi, manghingi siya ng retirement. Sabi niya, hindi ka naman bigyan namin ng retirement kasi project employee ka. Kada project, natapos ng employment mo, kada project. Nag-file ng kaso, nanalo si Estelito Hamin because the repeated rehiring and he is a member of the work pool transforms the nature of his employment from a mere project to a regular and permanent position. Take note of that, ha? Bang tanong, gaano kadalas ang minsan? Minsan, madalas. Ang basis lang. Yun, ulit-ulit. Naging regular na tuloy. No? Kayong mga lalaki, mahilig kayo sa gaano kadulas ang minsan. Ngayon, napaulit yung minsan. So, nagiging regular. So, yung 2 kinds of regular employees, regular talagang necessary and desirable. Meron pang mga casual employees, but whose term exceeds 1 year or has reached 1 year exact. Their tenure has been elevated to regular only insofar as that particular activity is concerned. So, ni-research ko lahat ito. So, you have to distinguish between project and regular. Regular is the rule, project is the exception. Ang project, one of the distinguishing mark of a project is that there is a beginning and an end. So, kung may construction project tayo, start tayo ng January, matapos tayo ng May, may beginning, may ending. Pero ikaw, maaring phase 1 ka lang sa project. Kasi ang trabaho mo is needed only in phase 1. So, after the completion of phase 1, hindi ka na kailangan. Pero may mga posisyon na work pool, kahit phase 1, phase 2, phase 3, nandoon pa rin siya hanggang naka-acquire siya ng more than 1 year or 1 year more, then naging regular siya. And then, even beyond that, pareho ni Estelito Hamen, in the eyes of the law, he has been regular employees. So, sa dami-dami ito, DM Consoni, ito yung sinabi ko. Can you see this in your screen? Attorney Wagas, makita ba ito?
Yes, attorney.
Yan. Yan, mama.
Yes, attorney.
Sino yan? Nandyan si Director Jimenez?
Mukhang wala, attorney.
Absent siya?
Mukhang absent.
Mukha. Ang mukhara ni absent.
No.
Okay, so ito si Estelito Hamen. Sinabi ko sa inyo, ha. Grabe ito si Estelito Hamen. Ang tagal-tagal na ito sa kumpanya. No? Biro mo, ito, ha. No, sa tagal na, no? 38 times siyang hinire. 31 years in DM Consonhi. Rehired for 38 times. Can you imagine that? Pagkatapos sabihin mong hindi regular, pareho na yan babae, ipuyo-puyo ni mo sulod sa 31 years. Unya pagkahuman yung dili magkanako asawa, pero gianak ka ni mo kapinsa na pulo, unya maingong ka nga, dili man tikaw asawa day. Anang casual ka man lang, project ka man lang. May project nga 31 years. Ang project na ay beginning na ay end. Unsa man ang project ka nga nahimo man ang 31 years. Pero sa construction industry talaga, merong mga legitimate projects. Ang requirement dito, there is a protocol. You have to inform the Department of Labor upon completion of the project. To show your good faith, if you are a project manager of a construction company, you have 100 employees in phase 1. Phase 2, you have 200 employees. Tapos, pag phase 3, 50 employees na lang. So, you have to report to the Department of Labor those that are not rehired because their skills are no longer necessary. So, you have to constantly follow the protocol in the construction industry because there is a separate department order issued by the Secretary of Labor by virtue of the delegated legislative authority, which is the implementing rules and regulations. No? So, if you do not follow that and the tenure has continued, then the complainant, the employee, will have an advantage in the hearing because you cannot prove that he is really a project employee. The presumption of the law and all the doubts shall be resolved in favor of the complainant. And you who allege otherwise must bear the burden of proof. by submitting substantial evidence. And what is substantial evidence? It is the degree of proof which a reasonable mind would accept to justify and support a logical conclusion, even if other minds are not similarly minded. If other minds do not think likewise, it does not discount the fact that you have proven your case. Itong kaso ng Universal Robina, ito ay ginagamit ng ABS-CBN to justify yung mga pag-empleyado ka ng probinsyano at matapos na yung probinsyano o mag-end na yung contract mo kasi project employee ka. That is just an coterminous with the project. Kasi ito si Justice Arturo Brion, who was a former Secretary of Labor. Nung siya na-promote sa Court of Appeals, ako yung nag-replace sa kanya as Undersecretary because when he was Undersecretary of Dole, he applied for Court of Appeals and he was accepted. So pumunta siya sa Court of Appeals, bakante yung Undersecretary, ako yung kinuha. Tapos, nung nasa Court of Appeals na siya, in-appoint siyang Secretary of Labor, balik na naman siya sa Executive. So, from Secretary of Labor, appoint siya ng Associate Justice sa Supreme Court. Siya yung bar top notcher namin in our batch. Sa batch namin, 1974, he was number 1. Ateneo ito, number 1. Number 1 sa bar ito eh. Pero ngayon, na-retire na. So, in this case, in the sugar industry, sa Negros ito eh, ang Gokongwei group of companies kasi, na doon na sila sugar milling, namalit sila mga sugar milling kay kanang ilang negosyo, mga food, manufacturing, kinahanglan ginag sugar. So, ito si Ferdinand Asibo, nag-file ng kaso, and ang desisyon ng Supreme Court is, kaya ang issue dito is what is the status of Asibo. Ang sinabi ni Justice Brion, gabuhat siya hybrid, regular, seasonal. Kay kini si Asibo, kinanglan mo lang ni sa sugar milling kung milling season. Kasi if you go to Negros, ang milling season, merong certain months of the year na tinatawag na planting, harvesting, milling. So ito si Asibo, kailangan lang ito sa industry kung mag-milling season. So, ang tanong dito, anong status ng mga ito? Ang sabi ng Supreme Court, they are regular only during the milling season. So they are called regular seasonal. So during the milling season, the owners of the milling company cannot hire other people. They have the right of first refusal. The work should be given to them because they have acquired tenure every season. So this is called regular seasonal. Where the workers, regular employees of Orsonco or Universal Robina Sugar Milling Corporation. Ito yung sagot ng Supreme Court. The workers are regular seasonal. No? Article 280, which is now Article 295. No? Para hindi kayo malito, yung dati na numero, dagdagan lang nyo ng 15. Kaya yung 282 ngayon, 297 na eh. 282 yung just causes for termination of employment. Ngayon, under the renumbered labor code, it is 297 because you add 15. 15 new articles were inserted in different parts of the labor code. So, starting book 5, mag-add ka ng 15, yan ang bagong number. No? So, maraming sinasabi ang Supreme Court dito. In fact, si Brion ay nagle-lecture what is casual employee, what is project employee, and now comes out with what is project employee and says that they are regular and also seasonal. You know, when the seasonal workers are continuously and repeatedly hired to perform the same tasks or activities for several seasons, or even after the cessation of the season, the length of time may likewise serve as a badges of regular employment. Kung kayo, meron kayong badges of fraud, meron ding badges of regular employment. Even though dominated as seasonal workers, if these workers are called to work from time to time and temporarily laid off during off-season, the law does not consider them separated from the service. Parang suspended lang ang relationship. It is pagka in between milling season, they are not separated. The relationship still exists, but it is suspended but because there is no work. Pareho sa hotel industry, merong mga waiters na mga on-call. They are not reporting every day because the volume of transactions in the hotel depends upon the rise and fall of customers. There are times like Christmas time when there are many parties, so they need more waiters. These waiters are on call. They are called seasonal but regular because the job of a waiter is necessary and desirable. But the tenure is limited to certain seasons. So they are regular and seasonal. I hope that you are following this case because this is very important. There is a definition. In fact, the case that I referred earlier, the case of Brent versus Zamora is discussed here. So even if the function is necessary and indispensable and desirable, it does not mean that it should be continuous. There are natures of operations like in private education, like this case of St. Teresa School of Novaliches Foundation, that their services are necessary on certain times only, not continuous. So if the company hires another group of people, knowing that there are already specific persons who have acquired tenure, that is considered a badge of bad faith. No? This is a very important case, that case of Universal Robena, because you will learn a lot of things from that case. Casual employees, indicators of employment with fixed term. Well, there is a difference between fixed terms and casual. Kasi in casual, hindi mo malaman kailan mo siya kailangan. Halimbawa, nasira yung tubo mo, tawagin mo yung tubero. Sino bang tinatawag ni Mrs. kung wala si Mr.? Di yung tubero. Yung tubero, nasira yung tubo. Eh di, yung tubero darating kasi wala si Mr. So, casual lang yun. Hindi yun ang sabihin na kada January nasisira yung tubo. Hindi mo natin maalam kung kailan masira. Yung pagpintura pa rin sa atip. Pipinturahin natin ang atip natin kasi dinaanan tayo ng bagyo. Oh. Those are casual work. No? Casual work, they are not predictable. No? So, you have to remember this, ladies and gentlemen. Ito yung Brent versus Zamora. Fixed term employment is not illegal. fixed term employment is not illegal. Ito in bank decision to, 1990, Justice Andres Narbasa. Why fixed term employment cannot be outlawed? Because if you do that, you are depriving the employer and the employee of their freedom to contract. You have a freedom to contract. In other words, the contracting parties have freedom to stipulate on whatever terms and conditions, provided that they are not contrary to law, public policy, morals, and so on and so forth. So if they are dealing with each other on an equal footing, more or less, there is no undue influence. There is no vitiated consent. There is no deceit, no misrepresentation. Then the consideration is not unconscionable. It is reasonable. It is fair. Why should the law, why should the court interfere in the autonomy and the freedom of the parties to stipulate? Although, of course, if there are stipulations that are grossly unfair, bad faith, then the law in the exercise of police power pursuant to the mandate of protection to labor, the law will come in to annul the contract, because the contract is so shocking to the conscience of man. And also the terms and conditions are grossly disproportionate, especially if it is a contract of adhesion where the consent was not freely given. So you should remember the elements of the contract: consent, object, and consideration. So if you are made to decide the validity of a quit claim, the validity of a resignation, you should look at the meeting of the minds. Was there really a consent freely given? And second, look at the consideration. Is the consideration just and fair? Is this not shocking to the conscience of man? So, if the answer is yes, you uphold the validity of the contract, because not all contracts, not all quit claims are invalid. Protection to labor does not mean oppression of capital. We should not use the law as a sword to slay the rights of the employers, because we should not kill the ghost that lays the golden egg. You have to remember that balance. Now, in the case of probationary employee, it's very simple. 6 months, you have, if within the period of 6 months there was no performance evaluation, then he is deemed to have qualified. The right of the employer to evaluate the performance of a probationary employee is limited within a period of 6 months. But for a teaching personnel in an educational institution, there must be at least 3 years, 6 semesters, or 9 trimesters, because to be a teacher is more difficult, and the requirements there is that you must be full-time, you must have obtained a rating of satisfactory in all the rating periods, and you must be a holder of a master's degree if you are teaching in college. And if these are complied with, then you attain the permanent status. Again, not regular status, because the regular refers to the position, the permanent refers to the status. So, from the beginning, you are a probationary employee, but you are occupying a regular employment, a regular position. You have to prove yourself within 6 months. Then, after that, your status is elevated to permanent. But all the time, your position is regular. See? I hope that tonight you have learned these things, because for so many years you have cobwebs in your mind. You are interchanging the word permanent with regular, and you are confused and you never ask. And no professor has ever explained to you. Only tonight. And there is one last question about probationary employee. Is it allowed by law to extend the 6-month period? Ang answer dyan, as a general rule, the answer is no. But in consonance with the decision of the Supreme Court in the case of Mariwasa versus Bueser, taga Bohol yan eh. Mariwasa versus Bueser, the Supreme Court said, if it is the employee who asked for extension and it was approved by the employer, and still after the extension, still she could not pass, and to terminate the employment after is not illegal. I'll give you the case of Bueser. There was a woman who applied for a job. For 6 months, her performance were evaluated, but it did not pass. But since she was a beautiful woman, and she was the muse in the basketball team, the management said, can we not give her another 6 months? And the HR is very wise person. He said, yes, we can do that, but you have, the girl must write me, and I will approve. So that was done. Di nagiging 1 year na, 6 months, hindi pa rin siya pumasa. So sabi na naman ng manager sa basketball team, bigyan mo naman kasi maganda yan eh. Mawala na tayo ng maganda dito. So, pinagbigyan, pangatlong 6 months na yan, 18 months na. Sa pangatlo talaga, hindi na mo pumasa. Tinanggal na siya. Nagfile ng kaso. Sabi niya, in the eyes of the law, my tenure has already been elevated to permanent. The Supreme Court said, no, you were asking for a favor. You were granted a special favor. You cannot turn around and say that management has transformed you into a permanent status. Para bang sinabi natin, wala kang utang na loob, kay gitagaan kag pabor, nahangyo ka niya, gitagaan kag pabor, niya pagkahuman, imo nang gamitin nga pabor against the company. So, the law in protecting the rights of labor does not authorize oppression of capital. He who comes to court must do so with clean hands. And under Article 19 of the Civil Code, every person in the exercise of his right and in the performance of his duty must act in good faith, must act with justice, give everyone his due, and observe honesty and good faith. In this case, the complainant was not acting in good faith. And so, the court decides against her. Because not all cases should be decided in favor of labor. Because management also has rights, which must be upheld. Nainumdum tuloy ko nga, doon ay kaso diya sa Mandawi, sa San Miguel ba. Kining mga empleyado sa Mandawi, kay 24 hours operation magbattling sa beer ba. Niya ka na mga lalaki, magbantay dito sa beer mo, tuyok ng mga botilya. Mabantayan man nila, kay doon ay mga foreign elements mo pasok dito for quality. Unya, for so many years, tagaan na sila mga bangkito, maglingkod na sila kay limang tibok gabi, graveyard shift ka, nagbarog ka. So na yung palingkura in town mi, lingkod sila. Pila ka tuig, abot na 10 years, galingkod sila. Yan ay abot ng bagong management sa Mandawi, yung di nato na palingkuron, kay daghang kayo nadakpan, nangatulog. Unsa man ang pagbantay ng mga beer nga naay masulod nga mga foreign element dia kay nangatulog man ang magbantay. So gikuha ang bangkito. Nagfile sila ng kaso diminution in benefits. So ang nagdesisyon ito mga arbitrator din sa Cebu pabor sa mga manggagawa, mga trabahante giingon nga mali man ang management na ay ngano lang gikuha ng bangkito, kadugay naman na that is a benefit. Ang sabi ng Supreme Court, ang benefit yung can be translated into cash. When you talk of benefits, yung mga you can transform that into money. You cannot transform yung bangkito into money. That is not benefit. That is a prerogative of management. In fact, napaganda pa yung katayuan nila kasi gikuha ang lingkuranan pero giminusan ang ilang hours of work. Unya, dagdagan pa yun ang kanilang rest period. Yeah, management was not unreasonable. And so, management said, it's not all the time that we decide in favor of labor. Although the state is mandated to afford full protection to labor, there are times also that labor should understand the prerogatives of management. Prerogative to hire, to fire, to transfer, to promote, to lay off, to discipline, and to establish rules and regulations. Because under Article 13, Section 3, management also has 3 rights: the right to reasonable return on investment, the right to growth, and the right to expansion. And property rights under the Civil Code of the Philippines. The right to manage your property is an attribute of ownership. The right to use, to dispose, to manage, these are inherent prerogatives of management. And if it is inherent, it does not have to be provided in the Constitution or in the labor code. I ask you again to subscribe to my YouTube channel. Just type USEC JBJ. Thank you.